Hey guys, welcome to the Exit Plan podcast. This podcast is dedicated to helping business owners transition to an exit. We will be hosting experts in all areas financial, legal, you name it, to basically help these business owners get set up for an exit. Today we have Pat Linden, who is a legal expert, M&A consigliere. Is that how you say it?
You got it.
Deal lawyer and founder of Linden Law Partners. He's been in advice on deals ranging from 10 million to 700 million dollars, and he's going to give us some advice. Pat, please, can you introduce yourself? Share with the people a little about yourself.
Sure. Hey, Valentino, Emmanuel, great to be with you guys today. Great work on your podcast and honored to be a guest here today. So, I'm a 25-year-old, not 20, I wish I was a 25. I'm a almost 25-year deal lawyer, corporate law, venture capital, securities, M&A. I really probably, I don't know, 17, 18 years ago, really had a heavy emphasis on the M&A space. Used to work for large law firms. I started my own law firm about going on 10 years this August. And really, what we focus on primarily is get outside of this, but sort of back of the envelope, call it 10 to $100 million transactions. Typically, that means we represent selling entrepreneurs and founders. Most of the time, these are deals involving private equity as the buyer, sometimes public companies. And, they could be an HVAC owner, they could be a technology guru, they could have a concrete company, whatever it is. They've built a great business, probably are not paired to deal with sort of the transactional rigor oftentimes that professional buyers bring to the table. So that's really what our focus is getting them through that for the deal of a lifetime for them. So, and that involves kind of everything from the ground up, psychological, a big part of advising people actually on the legal end, which I think a lot of people don't appreciate, is a lot of deal psychology that's involved, making sure everything translates through the contracts, execution, pushing back on over aggressive buyers and their attorneys and so on. So that's really what our story and our history is.
Absolutely. So the way we're going to play it out is I'm going to ask a question, follow up on your answer, and then Emmanuel is going to ask a question. We're going to do a little back and forth on that. So you call yourself an M&A consigliere, and I feel like I'm saying it wrong.
That's a heavy word.
Yeah, what does that mean in practice, and how do you support founders differently than a typical deal lawyer?
It's a great question. So, I mean, consigliere, in my view, comes from The Godfather. For The Godfather, it came from the real mafia, and Robert Duvall, famous actor, was the consigliere to The Godfather, who was an attorney. But consigliere doesn't necessarily mean you're an attorney. It just means that you're a strategic advisor, basically. And so it's kind of just a fun connotation on that. I also had a podcast at one point called the Biz Mafia podcast. But so consigliere and how would I say I'm different from your everyday deal lawyer? And that's a broad question, right? But let me just give you a little bit of perspective. So
Sure.
if you're selling a business for $150,000, and I might get involved in, certainly I've done plenty of those in my day. I don't do a lot of those anymore, but if you're involved in a deal for $150,000, a couple $100,000, it might be much more akin to a real estate closing. It's a pretty small real estate closing. You've got a broker involved, you've got a buyer or seller, they kind of put together some form agreements. There's really no back and forth. You're kind of almost executing a closing, and there's not really a lot to it from that perspective. I think a lot of times most people will have a perspective of a deal lawyer is what I just described to you. But as the dollars go up, and frankly, even on a lot of small deals can be harder than big deals, believe it or not. As I'm sure you guys are aware, Valentino,
there's a lot of emotions involved.
A lot of emotions involved. Sometimes the parties aren't all that sophisticated. Sometimes they bring their
cousin or uncle.
They might bring their uncle who is a trust and estates lawyer and trying to sell a business and all that kind of stuff, right? But to go back to your original question, I don't view myself at all as just a lawyer at this juncture of my career. I have a lot of legal experience. I've probably spent 100,000 hours writing merger agreements, buy-sell agreements, stock purchase agreements, rollover agreements, everything that gets packaged in a deal. But you learn a lot through that process of kind of like where value eradication might be. Going back to consigliere, one of the things in The Godfather is, lawyers can steal money in all the paperwork that's involved, right? So just because somebody's an accountant or whatever doesn't mean the working capital is going to perfectly flow through the contract. Most people are not reading the contract all that closely. You're often dealing with very high-end attorneys that have massive egos. They think they know everything. They've come from these Ivy League schools. Dealing with private equity guys who have massive egos. They come from these Ivy League schools, but they do have a lot of money to get through a transaction. So there's a lot more than just documents and kind of form checking it when you go back to that original perspective. I mean, sometimes you got to tell your client, like, hey, this is a semi-business legal issue. You need to push back here, here, and here if you want to end up here. Or if you want to monetize this additional $5 or $6 million as an example, that's contingent on the back end, well, you got to take some strategic steps. You don't just have someone put in their first draft of a contract, I'm going to do it, and you're also going to be subordinate to a mountain of debt that they have, or all the kinds of things that go on. So, you really have to be, you got to be pretty scrappy.
Yeah.
You got to be willing to push clients sometimes to boundaries they don't want to go to, recognizing it's always the client's call. But sometimes, like Valentino, I might go, hey, do you want the $5 million here, the minimum, or do you want the $9 million that you thought you had a deal on?
Right.
I'm guessing you want the $9 million. So sometimes I got to take some tactics and all that to traverse some terrain to get you from that 5 to the 9 million. It also means, for example, monitoring accountants. Accountants are great with numbers, are typically not good with contracts. So I have to understand very well the way that they're seeing the numbers to make sure it's reflected correctly, as well as just kind of double checking people as a general rule of thumb, right? I think that's what a great advisor does in general, and certainly a consigliere. So I think about it as more strategic, and it's the whole picture, and then the lawyer part sort of is table stakes.
I like that. A lot of people think lawyers, they just draft up the documents and let it be, right? From what you're telling me, you seem more like an extension of the buyer or the seller, a part of the
100%.
deal making. A lot of people don't understand that, but most of the value in the transaction is the structure, not really the price, it's the structure.
Absolutely. You just nailed it. And here's another thing I know we relate on, just kind of seeing and interacting on some of our respective LinkedIn comments. The structure is everything. And one of the biggest mistakes that sellers make, and it's nothing against sellers. Sellers are in the business of, like I said, they could be an HVAC person, whatever. They are experts there. They're not, even if they have command in general of transactions and they don't do dumb things and all that, because I don't think people that build a company to that extent do dumb things as a general. But as an example, I could barely screw in a light bulb, so I'm not going to profess that suddenly I'm even an amateur level construction guy. And the fact is, there is some there is some, there's a transactional acumen that you need. You need that advisor in your corner for anybody to give you $1 million, $2 million, let alone 10 million or $100 million. And just not going to do that on a handshake and without some serious possible consequences. So in terms of one of the best things that you can do, where most people fail because to their credit, they don't have the benefit of seeing everything on the front end, it's not their profession, would be the letter of intent and structure. I see way too many letters of intent where a broker has prepared, no disrespect, brokers, you guys are not that good with contracts. You're not. And just no more than I would be any better than them at understanding the exact EBITDA multiples and whatever. Right. I can have a generalized viewpoint because I'm in the business where we deal with those, but I'm not out spending 10 hours a day understanding, high-end multiples and ranges in this industry or this or that or whatever. Also not out every day, all day building spreadsheets and all that. So sometimes I think as a deal community, we're a little bit naive in thinking you're going to come in and you're suddenly going to see all of the angles. Like, for example, I can tell you if I'm doing a letter of intent and somebody's very generalized about rollover equity, or they're very generalized about earnouts, or they're very generalized about not wanting to talk or disclose how much subordinated debt they're going to stick on you. Well, you're just going to outstructure yourself to the point where you just eradicated a lot of value. So to your point, structure is huge. And in most transactions, 10 to 100, anything short of 100 million, a lot of times even bigger, you don't just simply walk away with all the cash in your pocket. You should endeavor to get a lot of cash, but a prudent buyer, and I would be the same way if I'm representing a buyer or I am the buyer, a buyer is going to want you to have some skin in the game somehow, some way in many instances. So you've just got to kind of sync those two things together and make sure you know what you're getting into through the structure from the beginning.
Absolutely. I mean, one thing that I was starting out, and there's a lot of newcomers in the M&A space, so they don't know much. But I was told never use the seller's documents. Draft your own, right? And I could share 2 examples to us. There was a broker, he was brokering this deal, and there was a LOI essentially. And then the LOI included a $60,000 escrow in small print, non-refundable if the transaction didn't go through. This other instance of a deal Emmanuel and I are currently looking at is a $14 million asking price trucking company. And the broker was telling me, well, there's $5 million worth of debt on the books. And the seller is asking for $14 million, which includes the debt. And essentially, they're going to use the proceeds of the sale to pay it off. So I'm like, if that's the case, why don't we exclude the debt? I pay you for what it's worth. And I deal with it because regardless, I still have to pay for it. How common are situations like these? I think these guys are doing it to test people, to see if they don't know what they're doing, see what they could get away with. That's an assumption. But I mean, there's a lot of newcomers. Can you touch on that?
Absolutely. I do think it's a combination of a couple things. I think in a lot of instances, people are trying to see what they can get away with. That also goes on at a far higher level, which I'll touch on a little bit as well. But you raise a great example. I think it's sometimes advisors that are, everybody seems to want to be in this space right now.
Right.
I don't know what it is. And they might even have a lot of experience. They might understand numbers really well, but they don't have what I'm going to just say transactional acumen. I'm not trying to be all hoity-toity about that. But let me, first of all, any transaction, and you hit it on the head, should be done on what's kind of a cash-free, debt-free basis. So you shouldn't be assuming debt and this, that, and the other, except for very extraordinary circumstances where there's always an exception on certain things. But for the most part, that should just be, when you start to see those total anomalies, something is off and it doesn't make sense. And you, as I say, like, here's the reality. Unless this is like you're paying Google type money or something, we're not going to suddenly be the first party that's not even going to make it on the page when you look at like deal statistics of like, I'm sorry, like that's just not going to be us.
Right.
Okay?
Yeah.
Not going to happen today. Right. The other thing though is I think there's a lot of inexperienced folks in the space. And I'm going to give you an example that I ran into just the other day.
Sure.
I got a phone call from a gentleman who's a super cool guy. Found me on the internet. That's cool. You know, like my SEO is working. And he just said, I'm looking for an attorney to hold the escrow. Some attorneys will still do that. I don't really do that. That does kind of go on at that lower. And the reason I don't do that is I don't want to be involved or connected in the deal in any fashion, particularly because as an attorney, you're always representing one side.
Yeah.
You could through disclosures and all that represent both sides, but that would be like conflict of interest 101. So it just doesn't make a ton of sense, right? So now you can hire an outside attorney, and there are a lot of attorneys that go, I'll charge you $2,500 or whatever, and but they're really almost just like a loan processor that's sort of neutral, which is what I believe you should do in those kind of situations. So he goes, I'm looking for someone to do that. I am neutral. He is neutral, and I'm basically, I already have the form agreements, and I just need an attorney to sign up. Now, there's a lot of problems in what I just described at a lot of different levels. First off, the broker's basically practicing law.
Okay, that's
because you can have form agreements and stuff, but at the end of the day, you can't really just advise people on those, and you're probably missing a whole lot of stuff. Like I promise you, if somebody sends me a form on any deal, and I'm not trying to be elitist or whatever, there is going to be some substance unless you've done this hundreds of times. There's going to be impactful things for all people around that I'm going to identify. And I'm going to, in some way, shape, or form, and by the way, I'm still looking for that form that's the perfect form because I don't like to bill hours just to bill hours. I like to be strategic and get deals done and make people happy. But at the end of the day, I have to do the job. So this guy is going, I have these forms. I just need you to rubber stamp it, send that form, check it, or whatever the case. And I said, well, how new are you in this business? He's like, I'm brand new. And I'm like, what's the size of these deals that you're doing? It's 160. I said, dude, I'm going to give you some advice. And I'm like, I'm not going to get involved in this, but you can call me anytime for me to give you some perspective. And what you should do is you should hire me to give you some off the cuff advice on how to do this. I'm like, the problem that and this is symbolic of what I see all the time, by the way. Problem with what I described there is that the broker is inherently conflicted if you don't take a side, first off, in my opinion. Now, clients can sign off on all of that, and that's fine. But then the broker needs to get out of the way, though, when it comes to the contracts and stuff, and not be like, I'm going to stick you in my contract that I got from my business brokerage people who don't want a lawyer involved because they just get in the way and blah, blah, blah. And at the end of the day, I want to get it done because I want to get a commission. Right or wrong, it's a problem. And it does not to say brokers are, I mean, we're all self-interested. I mean, I want to get paid. I do my deals too. And by the way, if I have a big fee, I am at risk a lot of times in getting paid because even if I'm billing by the hour, a lot of times the client might not have the money to pay me if the deal doesn't. So to some degree, we're all stretched by that. But then as the attorney, you can't just come in and a broker puts that and then and you're holding money. Now, that example is a couple things. That's primarily people not understanding the nature of a transaction, not actually understanding truly what conflicts of interest are. You got to be in a few deals and get close, dangerously close to conflicts of interest. I have. We all have. To really then appreciate, like, damn, deals are really about, yes, it's about coming together, but there is a self-interest. And it's really, so that's where I think a lot of people would be well advised if they want to get into the space or whatever. The first thing you need to do is don't expect a proficient lawyer to just quote sign off on your documents or whatever the case is. And don't expect it to be too easy, and don't put yourself in those kinds of positions. And when you are getting into these weird things, like you just said, Valentina, like,
Yeah.
some things are like, just you're getting too smart, too cute.
Yeah, let me just add a comment before I hand it off to my partner here. But one thing I used to see, and I was told a lot, is that valuations, in the finance side, they're inherently biased. The seller wants to get the most amount for his business. The buyer wants to pay the least, right? So you got two conflicting sides. I assume it's the same in the legal. Have you had to battle lawyers on your end?
Oh my God, man. Like, do you see these bags forming a little bit under my eyes? And I got some hair color that I put in because I'm gonna do some pictures tomorrow, but I got a ton of gray hair. And
Yeah.
dude, like, yeah, I mean, the amount of scrapes that you get into if you're a real attorney of any sort, let alone a deal attorney with $1 million going back and forth, are there's too many to count. And it's not because the general public, and frankly, even a lot of people that, they could be an investment banker, they could be a private equity guy, whatever. There is definitely something to people over lawyering things. The amount of over lawyering I've seen from people is mind numbing. A big reason why I started my firm, by the way,
Yeah.
was because I'm like, like, working at big firms, and it's just levels of bureaucracy that you can't even fathom.
Right.
But here, going back to your point, yeah, like, there's inherent advocacy levels. What you're talking about on the valuation side is,
Yeah.
there's a level of advocacy. And no matter how objective everybody wants to be, there's a level of advocacy. And nowhere is there more advocacy than on the legal end, where people are trained to advocate. And at the end of the day, you can do all the finance in the world, but it has to go through the contract.
Yeah.
And when things don't work out, dude, let me just tell you, it's ugly, man. Okay, I actually employ 2 litigators at my firm, not because our deals go south, but businesses get sued. Partnerships break up. When not done correctly, deals, especially if you're buying and selling businesses, and particularly lower size businesses, because it's a lot more Wild West.
Yeah.
Don't think for 1 second you're going to pick up the guy and you're going to have some cutesy, peachy, happy conversation. And no, you're going to be talking to some pain in the ass lawyer.
Yeah.
Who's not going to cut you any slack. And guess what? They're going to read the agreement verbatim, and they're going to twist the agreement and all that. So if you don't have a lawyer who's not advocating for you, you got the wrong lawyer, man. Like, if you're not willing to advocate in this business, including the M&A business, so, the amount of, like, gamesmanship and whatever that I see from private equity, and the issues that we have to get into that have nothing to do with going, oh, this rep is correct, or we're talking about, governing law or whatever. What we're arguing about are you trying to move millions of dollars, or put all the risk on contingent consideration that's millions of dollars, and give yourself clawbacks, and frankly, want to hedge your bets on things where there's no bet hedging going on. When you private equity group when you commit, when you do your valuation and there's a consensus on the valuation, I'm going through this exact issue right now. $40 million transaction, $32 million in cash after payoffs, $8 million in rollover equity. Started with a bad letter of intent. And it was like, oh, here's the enterprise value. You're going to get the same class of equity. It's all happy. Well, guess what? That changed. Another point, Valentino, no one understood the importance of structure at the beginning.
Wow.
That changed to now fighting tooth and nail over that $8 million because they're treating the $8 million like it's conditioned on employment, where a seller, there was never any understanding the seller was even going to remain on board. And if they were going to remain on board, it was short term. So then when you're reading terms that say things like, hey, if your employment discontinues for any reason, we can call your $8 million at a discount. Well, that's fundamentally a problem. You see what I'm saying?
Yeah.
So the first thing is you call out the lawyers and you go, no, this is like us writing a check for $8 million. Then, of course, these lawyers and these PE groups will take it another step and they'll make it so, and it's like, okay, if you must have some coupling of the two, then for you to be able to exercise this $8 million hose job, then my guy's got to go off the deep end or whatever. So then you'll get these things back that say, well, we can terminate it and it's just mind numbing. So what do you think you got to do at that point? At that point, somebody, whether it's the lawyer or whatever, has got to step in and go, bro and bras, it's $8 million and it ain't happening. You can try to get as cute as you possibly want. You can try to write in whatever you want. You can try to tell me your private equity bulge bracket, whatever. But guess what? One thing I learned in law school is how to read. And the deal is we're getting our $8 million. Period. Unless we shoot somebody in the head. If we shoot somebody in the head, you can take it back. Short of that, that's not going to happen. So you're laughing. This is actually what you deal with on these
But I
deals.
laugh because it's relatable.
It is very
But I
relatable.
can hear the passion in your voice.
And you
I
and
get the
I
same
sit
way.
there, and I sit there because I'm on the buy side a lot too. And I don't try to overthink it. I don't try to overdo that. I'm just like, look, there's a basic level of protection. But I'll tell you, when you're selling a business, this is what you're going to deal with. So when you come back to structure and everything at the beginning, you want to walk in at the beginning when you have leverage and go, by the way, you're going to show me your cap table and you're going to show me your valuation while I still have 3 or 4 buyers on the table. And we're going to be real clear on the circumstances by which I can retain or not that $8 million, because you're giving me a $40 million valuation. So if I'm only taking 32 in cash, I better get $8 million of real and valuable stock, right?
Yeah.
Those are the kinds of things that happen. That sounds crazy. That's actually not crazy at all. That example that I've given you, that happens on the daily. So it's you want to be professional, you want to be cool, you want to be reasonable, you want to do those things, but inherently in making deals, that is the way it goes. And somebody, oftentimes the attorneys, it's not about happy talk at a certain level. It's about angling to get the outcome you want. Now, of course, if people don't care, if they're cool with a $40 million enterprise valuation and 8 of it being fictitious, okay. But I haven't seen that happen when you actually break it down that way.
Pat, you sound like the right guy to hire. I love it. Let me pass the mic to Emmanuel. Emmanuel, please feel free to ask.
I mean, I've been listening to every single thing you've been saying, and I've tried to pinpoint the detail based off our experiences. And you've handled more than $700 million deals, right? And what separates a smooth transaction with a disaster, legally speaking? What's the difference that you would say that this deal ain't going to happen this deal's a red flag, and this deal is perfect on the table. So could you just enlighten us with that?
For sure. So understand that, especially if you're talking about a $700 million deal, and those are back in the days when I was pushing paper largely for other people or whatever, but I learned a lot about when you're talking about a $700 million deal. First of all, there can be all kinds of insurance mechanisms, and everybody's very sophisticated. And typically the sellers are incredibly buttoned up and all of that. There's actually a lot in the scheme of it, even though the number's bigger, there's probably less overall risk in a deal like that than in a $10 million deal where, for example, there might be a plumber who built an awesome business, but he did every deal on a handshake. They didn't really have great numbers, et cetera. But at the end of the day, they're making a lot of cash because there's a lot of things, maybe didn't have everybody on the payroll correctly.
Yeah.
There's more legal risk on those particular types of deals. If you're talking about a really high-end deal, the legal and all that's going to get done. Everybody's operating at very high level. There's just certain things that you're not going to tolerate. If I'm going to pay you $700 million, you're going to have no latitude not to give me a rep and warranty on absolutely everything. Okay. Now we can talk about limits and all of that. So let's now go downstream where it becomes more easy for deals to blow up. Very easy for small deals and deals between that 10 and 100 million I'm talking about to blow up in a couple different regards. So the first thing is nobody should really be, as a buyer on any deal, you should never be taking a legal risk. Let me break that down because I don't want the audience to misconstrue that as. So what I'm saying is, once you and I negotiate what are the limits of liability, like when you buy a car, I bought a Mercedes, I know that I'm going to get a baseline 3-year, $100,000 warranty on these categories. And that's just kind of like we're all sort of on the same page. We can argue about that a little bit, but that's sort of what it is, right? If you didn't maintain the engine, if you didn't tell me about a lawsuit, if you didn't pay your taxes, you should reimburse me for that within the negotiated limits of everything. So you enter into a purchase agreement, you write a standard set of reps and warranties. The buyer really shouldn't be taking any legal risk. If the seller has a legal issue, they should basically pay for it. Now, the problem with this risk allocation thing, though, is payment risk, okay? What the buyers do, though, is they shift financial risk, candidly, oftentimes by being able to sit on my money way too long, writing reps that are no longer predictable, okay? Writing reps that become business reps. Let me give you an example. 10b5 rep. There's nothing that you didn't tell me that if I was to invest in this deal or buy this company that I should have known. Well, that could mean a million different things.
Yeah.
That could mean anything. So you get into the deal doesn't go right. Or let me give you another example, the rollover example. I don't want to actually commit to pay you that $8 million. That's what's actually going on here. What's going on in my case is you have a aggressive private equity buyer who goes, there's more value to me. Think about it. If I bought Valentino's business and I want to roll that again and again and again, is my business not more valuable than if Valentino is forced effectively to stay there for forever to really get the benefit of his $8 million that he just reinvests? Of course it is. Okay. Yeah. But that ain't the deal. Deal is this deal right here is worth $40 million. So that is a business shifting risk. Working capital is a business shifting risk. Me writing flimsy stuff into a promissory note where I, as the buyer, can screw you for any number of reasons that don't have to do with legal risk, that is business risk being transferred to people. So what I argue over, even though I'm a lawyer, is I'm arguing over business risk 9 times out of 10. If I'm arguing over legal risk, I'm arguing over ambiguities where somebody's broadening a legal risk that really is not my responsibility. But the scrapes and the actual stuff where money moves and why having a great attorney matters so much is going, that's not what the deal is. And that's where I think a lot of times between buyers and advisors and whatever, we lose track of with all the nuance, people not wanting to appropriately allocate the business risk. If you buy my business and you screw it up, that's on you, man. That's not my problem.
Yeah.
Right. And that sounds simple, but when you get into 100-page agreements and this and that, and people that are not in the same direction, and the finance guys are here, and you got, egomaniac, Ivy League, New York lawyer over here who's never been wrong about anything in a contract. Okay. You can see where, these are, they can kind of take a life of their own on.
Pat, we got 15 minutes. I want to shoot you with rapid questions. Give me rapid answers. This is a very important one. Non-competes. How enforceable are they, and how important are they essentially?
Well, they're incredibly important because you wouldn't buy a business to turn around and have the seller compete with you. They're very enforceable. One of the exceptions is in any state, essentially, whether you can enforce non-competes for sure on employees or whatever, but sale of business is pretty much always going to be enforceable. Sometimes if you try to make it 100 years or 20 years or whatever, but for the most part, as a seller, you should be prepared and not pushing back a whole lot on the non-compete if it's a 3 to 5 year non-compete, because they're buying you to stay out of business.
Right. That's a red flag I see. I mean, if the seller's saying motive of sale is retirement, but they're fighting that non-compete, I don't know. Is it really retirement?
Well, it's not. Yeah. I mean, I like that too. Why don't you pay me a lot of money for me to turn around and do the same thing that I developed?
Yeah.
Absolutely. Should we negotiate as a buyer, structure or price first? I feel like in negotiations, brokers want to push price. Hey, it's 9 million and we want it all up front.
Structure.
Usually, when we deal with brokers, they do not want to talk about the structure at all. They just want to know how much are we gonna, pay. And I think this is not just us, but I think everyone's facing this. How do we go about from there?
Well, so that's a great question. Well, of course, the broker, because remember, they're self-interested and there's a conflict of interest. So that, however, here's what you got to believe in this business. If you're going to be an advisor, and particularly as an advisor, but the companies as well, certainly the clients, because at the end of the day, the clients are what really matter. You have to have a lot of intestinal fortitude and belief in the research and the due diligence and everything you've done. So what I mean by that is, if you have a selling broker who's telling that, you just got to blow it off and let it go in one ear and out the other. They're going to find out the hard way. People don't just go around and throw money around when they're buying companies, okay? And if they did something really stupid, and you don't want to do that deal. So I let a lot of that stuff go in one ear out the other and go, thank you very much. Can we get the information? We're going to run our own value. You're going to understand that value. You're going to believe in that value. You're going to believe whether that value is fair, because you're not going to try and get one over on someone if you want to do it right. And you let the rest of it fall by the wayside. And if people don't want to entertain that, if you're being professional and cool about it, then walk and find greener pastures. But here's the thing though, people get emotional. They want to get paid. Clients get overly attached to it. It's just human nature. And then they get pregnant with it, or they make a bad move and they overpay because they're not thinking objectively.
I like that. Say I go pursue an off-market deal. I got my team. I'm ready. I got my finance guys. I got my legal guys. The owner has never sold a company before. This is his first time selling it. Should I recommend that he gets his own legal counsel before we engage in negotiations? And if he doesn't, during the negotiation, can anything be reversed at close or post-close? As in the sense that we were trying to take advantage due to his lack of knowledge.
Okay, I see what you're saying. Well, would you in your instance be like, would you be saying, like, if you were representing the seller, you were on the buy side?
No, say I'm a buyer directly. I want to go buy this small company, and I come in with my guys, but he doesn't know much. So he's just going off what I'm telling him and what I'm structuring. And he doesn't have nobody on his end.
That's a fantastic question, man, because as much as I look, at the end of the day, if somebody's going to sell me a house in Kauai for below market and I don't defraud them and they're willing to do it, I mean, I'm probably going to do it. I mean, that's a lot of people, look, for everything I'm saying, it doesn't mean that I give all my cards away to the other sides. That's a great question. What I would
Because what I want to know,
I don't know. I'd have to
yeah,
actually think
because what I
about
want
that
to
a
know
little
is,
bit.
hey, I buy it for X amount. He cashes out. Transaction's done. He goes to his buddy or somebody, his financial advisor. Hey, you could have actually gotten this. Let me review those documents. Wait, what is this? Can he take me to court post-sale? Or is one and done? It's done.
No, he can't take you to court. Now, anybody can sue you for anything. They can say, gee, I wish you know, but you don't have it. Well, you don't have a duty. You don't have a legal duty. Just like a real estate agent doesn't have a legal, working for the buyer doesn't have a legal duty to the seller. Now, so no, that does actually happen. I mean, I see tons of deals. I'm like, I can't believe that you did this, but whatever, right? Like, but all that said, let's go back to, I think, what you're raising, because I want to make sure that we've thought about it from a principle standpoint.
Sure.
What I do know too, though, is and you guys both know this, once you get into deals, they can be messy and everybody hasn't thought through everything and things change. So I do think there is some logic to going, hey, here are my key points. I don't intend to change my key points. I don't want to retrade my key points or whatever. So I want you to know, because you are kind of business partners in the deal, even though you're on opposite sides of the table, I want you to feel very comfortable. So do what you need to do. Sometimes people go, I'm going to bring in an advisor, or they don't. At that point, you've kind of done all you can.
I like that. That's a great answer. Broker says, hey, you can't speak with the seller. You can't speak with the accountant. We're only making sure we have serious buyers. We want escrow. We want this. We want proof of fund. We want everything. What do you do?
I do think there is some validity early on in the process to running that process from the sell side to get a competitive offer. I do think there's some validity to wanting to have proof of cash so that people are not wasting time. And I think there's some validity early on to, as an example, providing a expression of interest, which is one step before a letter of intent to get it. But there is a point where it's just, you're going to have to allow some level of engagement and to ask all the normal questions and all that. So there's definitely a balance there.
Right. I've also noticed a lot of people are kind of scary when it comes to the LOI. They don't want to scare the seller off. So they'll come in with a very basic, bare bone LOI and then come and try to uppercut them with the PSA and have every clause in the book. How do you balance it out so you can convey, hey, this is what I'm looking for up front without scaring them too much with a 30-page LOI?
This is an awesome question. My phone is giving me, can you guys bear with me for 1 second? I got to plug my phone. Okay, and so I had to do this from my phone, which is kind of a drag.
Oh, no worries.
This is, first of all, this question is something, let me sit down. So your question was, do you want to restate the question? So
yeah, absolutely. Yeah, a lot of buyers will come in with a very basic LOI to try to hook the seller, if you will, and then finish off with this very long in-depth PSA, and then the seller's like, hey, we didn't review this. So how can we essentially set the tone early on And how do we ensure we're conveying what matters without having these 30-page documents and scaring them off?
100%. So here's what I would say. This is an area that I write a ton on, I speak on. It's one of my biggest, I think, key pieces of advice when anybody's doing a deal, which goes back to the importance of the letter of intent. As a general theme, a buyer is going to be interested in it being more minimalistic strategically, because the buyers, once you sign the letter of intent, typically the leverage normally shifts to the buyer's favor. Buyer can, as I put it, you can get pregnant with the deal at that point. And that's really more of a seller problem. So a lot of times when I'm on the sell side, I'm like, I mean, you're not going to have the entire purchase agreement there, and you can't, because there's still due diligence to be done and all that. However, most terms are driven by market. That's just reality. So there's a lot of things that you don't need to have an illustrious due diligence exercise to kind of agree in principle on, right? So if I'm on the sell side, to avoid this exact issue, it'll be like, well, we're going to negotiate the parameters of the reps and warranties in general. Now, if you run into some massive issue, of course, we're going to revisit that. We're going to agree on the general parameters of the price, for example, or even it might be working capital. Yes, you're going to have to validate it, but here are the parameters. The note, when you say you're just going to give me a promissory note, I'm probably going to say it's going to be secured by XYZ collateral. You're not going to be able to offset it under these things. You're not going to make my employment contingent or the rollover contingent. So those kinds of things, which you can get that sort of comprehensive detail in a 3-4 page document. You really can, right? Those core business things. On the buy side too, even though I said there can be a benefit on the buy side to being more minimalistic, what you want to do is think about it sort of in that same vein. I'm going to expect reps and warranties. You might even dive in to go, okay, here's what the limits of liability are, because you know that conversation is coming. Here's what my expectation is going to be on your transition plan. Here's what my expectation is on this. And if we have a problem in these particular areas, here's what our base recourse is. You and I can have that discussion, and you and I can get that sort of density in 2 or 3 pages, and we can make a hell of a lot of headway. And once we've done that, now we're just kind of building the content and the purchase agreement around that. So I think even on the buy side, even though a lot of people want to not be transparent about it and then drop these 80-page agreements on you, there's no better way to piss somebody off, first of all, especially a business owner.
Yeah.
Because business owners, for the most part, are used to doing a lot more handshakes and stuff in their day-to-day business than doing that. So I would urge people to be a little more robust. You don't have to do the whole deal, but you got to have that, because then you're wasting a lot of time and money when you get into it later and you layer on all of this stuff and you realize that you didn't really have a deal.
I love it. Last question. What are 2 to 3 clauses that your LOI should include on the buy side for protection?
You want to have some statement about general expectations on reps and warranties. One, because some sellers are like, I'm just selling it as is, like, which could be a problem, right? Because you don't want to buy, especially if you're getting SBA financing and all that. You don't want to be. That's a disaster, right? So you want to understand that. You also want to understand a basic amount in 99% of cases of the working capital. You don't want to buy a business and then learn that I actually have to fund a bunch more money to keep this operational, because that just means that you, for all intent and purposes, increased your price by the amount of that, right? So I think there needs to be a fundamental understanding of working capital, even though that often gets worked out once you get in the deal. Because as you go down the scale, a lot of sellers are not thinking about these things rightfully.
Yeah.
So I think it's up to you to protect yourself on that. And then the other one is, I think that you want to have understand and clearly put what the structure is in the deal. Because if you come in and, as an example, and you say the price is $9 million and you haven't articulated the structure, a lot of people are going to hold you accountable to go, what do you think that $9 million means? And pretty much every realm of life, other than buying and selling businesses, $9 million means you get paid in cash, right?
Yeah.
So I think to save face, to lock in things, make sure you really have a meeting of minds. Those are three elements as a buyer I think you want to touch on, and you're not just touch on, but I think you want to have a solid understanding in the letter
Pat,
of time.
it's been a pleasure to have you on this episode. I hope I could steal you for a part two, man. You're just so insightful and passionate. I've been in private equity for the past 5 years. I know a good lawyer from a great, and you're amazing. Thank you.
Guys, you're awesome. Thanks a lot, man. Appreciate it. All right.
Have a great day.
Pat.